Okay, so welcome back after our break to this last panel of the day, which is going to be chaired by my dear colleague Lucila de Almeida, who is also the director of the Green Lab at NOVA, where they do a lot of very exciting work on the environment and ESG, but focusing on the E. And Lucila and I have been collaborating a lot, and the Green Lab is also one of our wonderful partners for this event. So thank you, Lucila, for your availability and for taking the role of the chair for this last panel. I will leave you the floor.
Okay. Thank you so much, Claire. First of all, let me thank for the organizers for organizing this wonderful conference. So my colleague, a brilliant colleague, Claire Bright, Laura, and Alison, who is just nearby next to me. So thank you for our audience who stay here. We are in the fourth panel. So thank you so much for being here with us. And I assure you there's worth. And the fourth panel is going to be due diligence and remedies. And perhaps when you think we are all, most of us at least are lawyers, when we're thinking about the title of our panel, the first thing that comes to our mind, okay, remedies. So if you're thinking about remedies in a strict sense, the terms often refers to outcomes of a lawsuit where the victims or claimants has received compensations or been in the form of enforced rights, penalty, monetary return. But this is not how remedy wanted to discuss here. You wanted to go to a broader concept of remedies, and remedies could be access to information that is based on the status quo, and this access to information will have consequence for the reputation of companies and the reputation of the companies. If it could lead to a correction of the actions, it's also a remedy. So let's think in remedy in a broad sense in this panel. And with this introduction, I would like to pretty much to welcome our keynote speaker, Professor Karin Buhmann, Professor of Business and Human Rights of Copenhagen Business School, and Professor at the University of Southern Denmark, and Director of the Center of Law, Sustainability and Justice. So, Professor, the floor is yours.
Thank you very much. Do I need to press anything here to speak? Can you hear me? Yeah? Okay. Thank you very much to the organizers, to Claire, and to Alison for having me here. It's my first visit actually to NOVA in NOVA's context of being, well, a university and with the Business and Human Rights and Environmental Center, so it's a great pleasure. I do have a PowerPoint, but given that we have fairly little time, I think I'm not going to share it. I'm just going to use it in order to remember what I want to share with you. So the title of my presentation here, I think I'm trying to see if I can get out of that light, is that I would like us to think about the topic of remedy, not just from the perspective of actually getting access to remedy through a court, which is one of the issues that the Sorry, do you mind not taking pictures when I speak? Because I lose my focus. Okay? Yeah, thank you. In the context of the EU's proposed Corporate Sustainability Due Diligence Directive, one of the novelties, the real, in many ways, potentially revolutionary novelties, is the introduction of a civil liability scheme, which by default also includes or allows for an opportunity for victims to sue EU-based courts or EU-based companies in the courts of the EU. So in other words, home state courts. So that opens opportunities for remedy. We might think that this really will solve the problem of lack of access to remedy. That is a long-standing, very well-recognized problem in the business and human rights field. But what I would like to draw our attention to here is that remedy is not just a matter of having access to, say, a remedy institution, in this case a court. Yes, that can grant procedural remedy, but that is not the same as also delivering substantive remedy, an actual form of reparation. And why is that? Well, that's because there's a lot more to actually not just getting to the court, but actually also getting through the court and getting your result out on the other end. And I speak, in a sense, with a background as a practicing lawyer. When I started studying law, doing human rights law many years ago, it was, like I think from a lot of other people, based on a motivation of trying to advance justice, and especially create justice for those who might otherwise not get it. But what I found was when we have civil law cases and civil litigation, it is so much dominated, at least in the civil law sphere that dominates the continental European countries and much of the rest of the world, basically all countries that were not some stage within the past few centuries, part of the British Empire or the UK or the US. The fact that in a civil case the judges must be persuaded by the arguments of the parties. Okay? So you may gain access to court, but that doesn't mean that you're also actually granted a case in which you get the result you come for, even if you have a really good case. Okay? That's one of the challenges of civil liability. So this is not to say that the problem of access to remedy is not very well recognized. It's very well researched in the business and human rights context. It's recognized both by the UN Guiding Principles from 2011 and the more analytical document that they build on, the Protect, Respect and Remedy Framework from 2008. It's been, the problem access to remedy has been documented also in multiple other ways, including by OECD Watch and SOMO in numerous reports, also looking at problems related to both to non-judicial state-based remedy institutions like national contact points and other types of remedy institutions. So in a sense, the idea of having access to remedy in the EU with EU-based courts for EU-based companies' impacts elsewhere is really a novelty. But this just doesn't do away with the big problem, which is not actually a legal problem, but is a resource problem. It's a resource problem in terms of access to knowledge about the law. If you want to win a case in a court of law, again, it's very much based on the best argument. How can you deliver the best argument? Well, it means that you must be an expert in the law that applies. So not necessarily not the law of your home country, but this will be, in this case, the law of the EU and the law in that particular EU country. Because we're talking about the directive, it's going to be implemented in each of the individual EU countries, which means that we're going to actually look at the law in 27 different countries. So that's a very important resource. And who have those resources? Usually lawyers have those resources. Now lawyers, there are a lot of them doing pro bono work, but in the corporate field, most of them don't do pro bono. They might do pro bono on the side or in their free time, but most of them deliver legal advice at a price. Getting lawyerly advice is a market-based good. And as with other market-based goods, you pay for what you get. And you often get what you pay for, right? So you can imagine, say, a rice farmer in Indonesia that produces rice for, say, rice puffs or something, produced by a European cereal company. And the possibilities of that rice farmer, or say a rice farming community, to battle in court in terms of arguments and the knowledge of the law, and also the experience actually in litigation, which is also something that is highly prized. We see it increasingly, law firms are creating specific sections with lawyers that are just really, really good at making the argument. Not everyone is good at litigating, right? Some are good at doing the research, others are good in really convincing the judges, right? So you can imagine how the situation or the lack of balance between that rice farmer and then the European company. And even if civil society organizations support the rice farmer or community of rice farmers, that too is a little bit of a tall order. Because here too, that we have the same issue of resources, of experience, and of knowledge resources, of experience, and also of funds to, say, work with law firms to get legal assistance in that sense. And from my experience as a member for 10 years of the Danish National Contact Point under the OECD guidelines, one of the things that struck me was that, as Joseph will remember, when the Danish National Contact Point was sort of revamped in 2012, there were big hopes in many ways, because it was the first national contact point to get a statutory basis. And it also had, it was given the power to take up cases on its own account. And it was also, there were also some additional steps in the process. And there was a really strong political desire to get more cases in front of the Danish National Contact Point. As a member that was a member of the contact point, appointed by the minister, but upon nomination by the Danish civil society, I had regular contact with Danish civil society organizations. And they were constantly lamenting that we do not have the resources to research the cases and to actually represent victims well. We need someone else to do it. And it's all very well that politicians and others are expecting civil society to do this, but we do not have the resources. We have other things to do. And depending on the funding of civil society organizations around in Europe, some of them are very highly dependent on governmental funding, typically more in developmental roles than in, say, roles of representing victims in front of NCPs, or it might be courts, right? So there is something in here where it seems to me that in order for the CSDDD to really deliver on access to remedy, there is need to think even more about these resource constraints, even more than what has been done already, because it has been addressed more intensely during debates also with the European Parliament. But there is still this huge risk of power disparity between the parties that is completely well known in civil litigation anyway. That's also why, if we look back to the 70s and 80s, there was a wave of introduction of alternative conflict resolution in both civil and criminal cases in Europe, based on, and elsewhere also, based on actually experience of other societies, societies that had other practices for dealing with conflicts, as well as some more sort of judicialized societies where it was an alternative, like in some places in the US. And that's still in many ways going strong. It's also what we see with the OECD national contact points. They have the opportunity to offer the good officers to victims, and in that way to help both explore the case, do research on the problem, on the alleged violation, and actually also, provided they're sufficiently staffed and funded, and work within an NCP that actually does that, they can also go and work with the victims and the perpetrator on location. So they can help to build that sort of communication to try to address the problem in a more balanced way, in a way that would be more difficult in a court of law. There is probably one really prominent example of this, which is the Dutch and the Netherlands NCP's handling of the Bradley-Heineken case. So this shows it can be done. It also shows that NCPs can use their good officers to actually facilitate an agreement on compensation. They cannot rule on a compensation, but they can use their good officers. There are also lots of other NCPs that are not very strong. The point I'd like to finish at here is that now that we get the CSDDD, or likely to get it, and the civil liability scheme, that's also a really, really good opportunity for EU member states that are members of the OECD, and that's not all of them, and I'm sure Joseph will be able to mention those that aren't, but there is not full consistency in that membership, to rethink their NCPs, and maybe also for, it goes on already, right, considerations between the OECD and the EU, but there's an important point, I think, in not throwing out the baby with the bathwater, because just because some NCPs are not well functioning, there are actually some that have been making a difference. So the fact that the CSDDD as a directive needs to be implemented through law or other legislative measures, could also be bylaws, in member states, is to me a wonderful opportunity to reconsider, hey, what are some of the strong points of NCPs? What are some of the weak points of our NCPs? Should we use this opportunity to award our NCP a statutory basis? and in that context develop a law that actually strengthens the procedure, provides it with financial resources on the national budget on an annual basis, requires specific qualifications for the chair, for the members, building on the models of some of the stronger NCPs. And in that context, it might be really worthwhile to consider how NCPs could also still work to support victims to address this power imbalance that victims may otherwise encounter in a court of law. For example, by, say, collaborating or assisting civil society organizations in some of the exploration or providing information that victims could use, maybe like we have, for example, in Denmark with the parliamentary ombudsman, if the NCP would find that there was say an abuse of the OECD guidelines, of due diligence in the OECD guidelines, then even recommend to the judicial authorities that the case would be handled say with increased legal aid. So there are multiple opportunities out there to actually build on this process to do even more to address not just procedural remedy but also substantive remedy. So that's where I wanted to finish. And just one more point, like why is it that NCPs are interesting? Also because the CSDDD is not going to do away with NCPs. NCPs, they will still be there in all the EU countries that are members of the OECD by virtue of their existing commitments to the OECD guidelines. Because the guidelines cover lots of other things. They do cover human rights and environmental due diligence, but they cover lots of other things also. Right? So anything that's not just within what the CSDDD will cover will still be something that the NCPs will do. So they're still going to be around. So why not maximize those resources for the benefit of victims and access to remedy? Thank you very much.
Thank you so much, Professor Karin. Then we move it from the keynote speech actually to the panel. And today in the four panel, we had the three speakers who would give their perspectives. And actually how we organized the panel when we discussed before, we thought it would be interesting that actually each one would give like their positions from their research, from their work perspective on the topic of due diligence and remedies in 7 minutes each, freely speaking, and we could go and with rounds of questions and see the point of view of each one in horizontal questions. So we started with introduce our first speaker in the panel, which is Joseph Wilde-Ramsing, Director of Advocacy at SOMO. And Joseph, the floor is yours.
Thank you very much. Yeah, we're going to try to make this last panel of the day a bit more dynamic and engaging and quick and snappy. So we'll see if we can do that for you. Yeah, thanks so much for the invitation and for the introduction. My name is Joseph. I've been with SOMO. The SOMO is the Center for Research on Multinational Corporations. It's an Amsterdam-based NGO that does research on the impacts of multinational corporations, and I coordinated the OECD Watch Network for a long time, which is where I met Karin, and we've worked together for many years in the OECD space. So I'm going to be talking a little bit today. I'm going to try to give 4 really concrete examples of remedy cases that I've worked on and use those 4 cases to highlight a few things that I think are very important for the CSDDD and for basically setting up a more effective system of remedy around business and human rights than we have today. The first thing, of course, to remember is that remedy is rare. We published a report, I think, almost 10 years ago today that was really focused mostly looking at the NCP cases, but you could have applied that basically also to litigation and civil cases, criminal cases, development banks, non-judicial cases. So it really is sort of the forgotten pillar or the forgotten element of the UNGPs. And the second thing to remember about remedy, and Karin, you alluded to it just a minute ago, and Sinisa also, is that remedy is about power. Remedy is about creating a more balanced system, a more balanced situation of power between 2 parties. And we know that we often have multinational corporations that have a high degree of power, and we have communities, affected rights holders who have a low degree of power. And so any system for remedy that is ever going to be effective at delivering actual meaningful remedy to people has to address these imbalances of power. And the law is, of course, one of the biggest ways that we can address these imbalances of power. And so the potential to have civil and criminal liability and administrative liability through a law like the CSDDD is, of course, a big piece that's been missing in the business and human rights space for many years. And I actually think that if the CSDDD comes and creates a genuine and effective civil and criminal and administrative liability system and active access to remedy, it will actually make non-judicial mechanisms like the NCPs much more effective, because the cases that there are now going to the NCPs, which the NCPs and other non-judicial mechanisms are not necessarily equipped to deal with, will be going to the courts, and the courts will deal with those cases, and the effectiveness rate of the NCPs will go up through the roof, I think. So that's my hope for the NCPs. But I wanted to mention 4 quick cases, and I won't go into too much detail because I'm tracking the time here, and just pull out a few lessons that I think are important for the CSDDD. One that has been, Karin just mentioned, it's not Heineken Ukraine, which we talked about earlier in the panel, it's Heineken DRC. It was a case in which workers in the DRC were unjustly fired in a period of civil war in the Eastern Democratic Republic of Congo in 2000. And after many years of trying to get remedy in the national context in the DRC, the workers came to file a case with our help at the Dutch National Contact Point. And through that process, Heineken ended up paying several million euros in compensation to these workers in the DRC, 168 workers, for the harms that had been committed. That was, to some degree, a successful case, but you should also know that their original claim was for 200 million in remedy, and what they thought that they were owed was 200 million, and what they actually got through the NCP process was around 5. So that it's, and there's some certain elements of that I think are important that I'll pull out later. The other is regarding a bank, actually, and a bank's contribution to harm. And so we talked a little bit earlier about the role that investors and financial institutions can have in business and human rights. And of course, it's a lot about using your leverage and encouraging your investee companies and your business partners to do the right thing and provide remedy. But it's also important to note that under the OECD guidelines, UNGPs, and hopefully also the CSDDD, although that's a big question now, financial sector can also contribute to harms and therefore is also responsible or liable for contributing to remediation. And so we've actually got a case that came from an Australian bank, ANZ Bank, that was financing a sugar plantation in Cambodia, in which villagers were forced off their land to make way for the sugar plantation. And through this case, the Australian bank actually agreed to pay compensation itself, contribute to the remediation of the harms. So that's quite an interesting case. Another case that was also mentioned today that I've worked on is Telenor, and not Russia, but Myanmar. And Telenor's, what I still am very much convinced was an irresponsible disengagement from Myanmar, and that's what the case was about. And this was at the Norwegian NCP, because Telenor is a Norwegian company. And basically, it was a situation, a very difficult situation of the coup. Telenor basically had to leave. I don't think anyone argued that Telenor could have stayed, because the regime was asking Telenor to install surveillance technology. And there is just such a difficult situation. The previous panel laid out some of the really difficult the situations in which companies can get on. And there's basically no right answer, staying or going. And it's just about how you go or how you stay. And so in this situation, Telenor was basically forced to leave, to disengage, but the way in which they did so had created a lot of additional harms for both the users. They basically sold users' data, personal data, to the regime for 100 million euros, which is a huge loss of their investment, which had been closer to $1 billion. So they took a big hit, but it's still, they made 100 million euros off selling these people's data to the regime, which endangered lots of human rights defenders, because Telenor had sold itself as being a responsible company. So all the human rights defenders and all the democracy activists signed up with Telenor and put their data there, and that was sold to the regime. And the other was on the workers. Telenor's own workers in Myanmar had a lot of impacts, because when they left, Telenor was seen as traitors to the country, and so because they had collaborated, they had sold their company to the military, and the resistance forces ended up targeting some of the Telenor workers in Myanmar, so there were some negative effects. And then the final case is related to what Colombian coal mining communities are now seeking. And this is an interesting one for the just transition and responsible disengagement in the just transition, and also with regard to legacy impacts and remediation around legacy impacts. There are certain situations in which we know a certain business activity has to stop. Fossil fuels, for example. Coal mining has to stop. Oil has to stop because of climate change. But the way in which that disengagement or that stopping takes place is very important. And we need to look at the harms that have been caused by these operations, by the coal mining companies, by the oil companies, and that remediation happens as part of the disengagement. So just to link to the earlier panel too, responsible disengagement is not just about looking at forward, okay, what are the impacts of the disengagement itself going to be, but when we leave, we have to make sure that we've cleaned our shit up, basically. We have to make sure that we've done right by the people who have been supporting us for so long. And I know you're going to speak about that a little bit more today too. So that's an important part. So just to really quickly round off then, taking a couple of examples from these three cases, it's really crucial that remedy be a core part, seen as a core part of due diligence. I think Claire mentioned this earlier at the beginning, but for example, the European Commission's draft on the CSDDD doesn't even mention remediation, and the Council's draft is also a bit flaky. The Parliament gets it right. The OECD guidelines and UNGPs are clear. It is part of remediation, part of due diligence. The relationship of contribution, linkage and contribution is very important, that it's not just one company who was on the ground, the mining company maybe that caused the impacts, but it's all of the companies that profited from it and benefited it and contributed to the harms that are also responsible for that remediation. And then finally, just the stakeholder engagement element, and that making sure that as part of remediation, companies are really engaging with the local stakeholders to make sure that they are able to express what they want, because again, like you said, it's often not just about financial compensation, but it's about information sharing. It's about promises of non-committal. It's about new opportunities. So being well in touch and meaningfully consulting the rights holders who are affected as part of remedy is crucial and important. Thank you.
Thank you so much, Joseph. It was a wonderful intervention, indeed, with concrete cases that you have acted as the institution of providing support for these communities to access justice and consequentially remedies. But then we move it to Hugo Albuquerque, who is the legal manager of SOMINCOR, and he will give like a perspective from company. Exactly.
Good afternoon. I want to thank you especially to Ambassador of Canada for this kind of invitation. Many thanks. I want you, George, please give my compliments to her. I was asked to talk a little bit about SOMINCOR. SOMINCOR, for those who doesn't know, it's a subsidiary of the multinational London Mining Corporation. It's the biggest mine in Portugal. The first, it is located in Neves Corvo mine. We explore the deposits of copper and zinc and byproducts such as lead and silver. SOMINCOR is the first producer of zinc concentrates in Europe and the sixth of copper. SOMINCOR adopted Lundin's mining mission and values that form the foundation of our sustainability approach. Our mission is to responsibly mine base metals vital to society and creating meaningful value for our stakeholders. The values that we share with Lundin, the safety, respect, integrity, and excellence, guide us in mining sustainably to contribute to a more sustainable world. Lundin Mining is a member of the United Nations Global Compact. Through this initiative, we have made a commitment to sustainable business practices, and we are aligning our strategies with these 10 principles on human rights, labor, environment, and anti-corruption. More than talk with you about what is our global strategy on sustainability, I think it's important to talk about some examples, because as we are talking about, I think it's more interesting for people regarding our as we align with the Global Reporting Initiative, Standards Framework and EU regulations. We implemented at SOMINCOR in 2019 a human rights risk impact assessment, and we have a community grievance mechanism. What we do with this, and this is very important, and because our values and our mission and our responsible mining policy lead us to other standards that we are on when we are executing this kind of values. And one of these standards is the Responsible Mining Management System standard that is more or less an audit. We have it biannual on social, economic, and environmental topics, and it was found in the last. It is made by a third part, a multinational, and they said to us that our mechanism of the grievances was not so known by the communities as we thought, because last year we had only 2 grievances that we resolved. So what we did as we speak, we are launching a new program that we call Fale Connosco, Talk With Us. And it is important because our communities can now, in a written way or a verbal way, they can formalize an issue, a request, positive feedback, negative feedback, and the grievances. And if it is a grievance, our community and corporate social responsible department lodge the grievance, and we committed to answer and to resolve this grievance in 20 calendar days. This is the community grievance mechanism, and that allows us mainly 2 things. First, to understand what are the real risks that we have around community, and avoid that an issue turn into a grievance in the future. So we can tackle immediately what are the little aspects that we can deal with, and if not, what will be the measures that we need to address in the future to resolve the grievance. And at the same time, of course, as we have a very good relationship with our community around Neves Corvo, it also serves the purpose of have a good relation and keep this good relation with our communities. Other mechanism that we have is the social license to operate. This is a survey that we done twice per year, and we send this survey to our communities asking 5 questions. What is the acceptance and trust of the community in SOMINCOR? Are things getting worse or getting better? What are the risks for our operation and our communities? Where should we focus our efforts? And how effective and impactful are our actions? And accordingly, with the outcome of this survey, we act upon. This is, and in a human rights perspective, and if I can separate this, we have also the closure plan. And as Joseph said before, we are, by legal, we are obliged to present a plan de lavra each 5 years. Plan de lavra is the life of mine plan. That includes another plan called closure plan. And this closure plan contains numerous measures designed to minimize the social, economic, and environmental impacts of the end of the exploitation, as well as technical measures of its closure. And it can be, and we are obliged to, by the government, to have a transitional social plan. And it includes things like training our workers to do a different thing in the future, help some little economical activities, around our communities in order to give them some tools to do other things when the mine closes. So, and this, as a remedy, we have to value this closure plan sometimes, and the last one is a lot of money. We are talking about millions and millions of money. And what we do was we create a fund, and this fund has a lot of money. Only the government can use it, because in the end, and as you know, we have a problem in Portugal about abandoned mines. If we don't close the mine as we agreed in this closure plan, the government will do it with the money that we left in the closure plan. Finally, what we are, because of the CSD-DDD, we are conducting an assessment to understand the key gaps in process and in systems against the 4 key pillars of CSRD: governance, strategy, impact, risk management, and metrics and targets. Thank you.
Thank you so much, Hugo. A very good perspective is always given as well, like the perspective of companies and how they proceed with not only the due diligence, but ensure that if there is any issue identified, how they remedy. As far as here, you are focused on remedy. And then the last is, I moved to the last speak, Alison Holm, who we know organizes this wonderful conference, or assistant professor of NOVA Business and Human Rights. The floor is yours.
Thank you so much. And there's a very high timing standard, as Hugo was spot on 7 minutes. So I have to do at least as good, at least as well. Thank you so much. It's really an honor to be speaking alongside such experts. And so I'm an assistant professor at NOVA School of Business and Economics. And I've been conducting a lot of research on the OECD guidelines for multinational enterprises and on the NCP system for the past several years. But my background is international business, and so I thought my contribution, to be the most complementary possible, would be to talk a little bit about the challenges that multinational enterprises face whenever they want to implement any kind of policy, may it be with regard to human rights or innovation or sales or production, you name it. And to think a little bit about how the NCP system, based on my research, can be leveraged to help overcome some of these challenges. So I started researching the NCP process because at the time it had been around for 17 years or so, and it also had been heavily criticized. So the NCP process was put in place to provide a pathway towards remedy in response to alleged human rights impact, but other kinds of impacts as well. But during its lifetime, it's been heavily criticized of lacking teeth, of not being able to provide effective remedy. And so my question was then, you know, it's been around, so there must be some kind of value in it. So I decided to look a bit closer at what kind of value does the NCP actually have. And it turns out the NCP is really good at teaching about international expectations, and firms who actually go through the process and engage with civil society actors end up learning a lot, not only about the expectations, but about their own activities. And that's really interesting from an international business point of view, because multinational enterprises usually face 2 types of challenges, at least for implementing any kind of policy. The first one is control challenges. Multinational enterprises are huge, complex organizations, and being able to control everything that's going on into this organization, but also with suppliers and partners, is a very challenging task. It is not being done, and it will never be done perfectly. So multinational enterprises, to be able to control what's going on in their organization and also outside with suppliers, they need information. And it turns out the NCP system is a really good way to get information. So multinational enterprises, when they're faced with complaints, a lot of them who engage end up getting a lot of information. But the problem is, the issue is that filing complaints on the civil society side is extremely resource intensive, as we heard from Karin earlier. On the NCP side, it's also quite resource intensive, and sometimes it takes several months before being able to accept a complaint. Sometimes it takes several years. So, by that time, a lot of new harm has been going on, so it's a bit too long. And finally, another constraint is on the firm side. Engaging in the complaint mechanism is something that firms have been reluctant to be doing, because it may signal some kind of admission of guilt or responsibility. And even reaching a solution and committing to changing multinational enterprise policies or committing to given some kind of remedy may also be perceived as admitting guilt. And so you see an additional reputational constraint in even engaging. So, to be constructive, because the NCP is such a learning platform, and some NCPs are doing this, and this could be leveraged around the system, is to organize, in addition to this complaints mechanism, more opportunities for discussions between multinational enterprises and civil society actors who are true experts on what's going on in the field, for informative purposes, in a way that firms engage on acting on the pieces of information that they're receiving. And this can be moderated by the NCPs themselves as part of their promotional mandate, so as part of the mandate that they actually have from the OECD. Another challenge that multinational enterprises face is this constant balance between integration and adaptation. What this means is multinational corporations need to strike the balance between having activities that are coherent across the whole organization and adapting locally in each subsidiary or with each partner. And this process of balancing is ongoing. It's particularly important for human rights issues, because once you have a human rights policy in place, say, for example, zero tolerance on child labor, you also need to consider what's going on in the local context, so that itself, the abolition of child labor, doesn't have itself other adverse impacts that you want to avoid. And this is also something mentioned in the CSDDD. So there's a constant need for adaptation. And from my research, I found that a lot of the complaints that are actually concluded on human rights, some do have some kind of backward-looking forms of remedy, but most often the form of remedy that comes out are forward-looking. So they're about committing to conducting due diligence. They're about acknowledging a general responsibility towards human rights, and the NCPs are in a unique position to accompany these multinational enterprises to actually meet their commitment. So meet their commitment of conducting due diligence by continuing this interaction with civil society on local context issues, so that firms can be aware that they actually need to adapt to these local contexts. I mean, they're already aware of that, but how they need to adapt. And this can also be moderated by NCPs. In the updated version of the OECD guidelines, the most recent update, there is an emphasis on follow-ups. And a follow-up should not just be a document that states, this and that happened 1 year after the case was closed. There is a real opportunity, and also in light of the CSDDD, for these follow-ups to actually be very, almost medium-term process of accompanying the multinational towards meeting its commitment with the help of society, and always in consultation with civil society. Thank you very much.
Thank you so much, Alison. It's always good to see what's happening on the floor when you were speaking about national contact points. And perhaps the second one you discussed as a panel, we thought that would be interesting to have like a round of questions, in which we would address the questions. We perhaps are a bit advanced with the time, and we had planned actually to have 2 rounds of questions. What I'm going to try to do is to merge the 2 questions, and then you can have only 1 round to give chance to collect questions and answers from our students and perhaps from the audience as well. So I think throughout the speaks, there were many references, starting from Professor Karin. I have a speech when she mentioned about the CS DDD, the fact that remedies has been very weak dimension of the CS DDD, and not only the CSO DDD, but you can cite as OECD guidelines. So you can identify some strength parts, you can identify not much strength, how much we should like it to, but as well like most weakness. And perhaps what I would like to listen from you, from your expertise, is if you wouldn't be the regulator, which are the pitfalls and which are the strengths if they have any? And if you would be wearing the shoes of legislator, how you would change it? What is good could be good amendments, perhaps. This would be the first questions, I would say, from bottom-up regulator perspective. The second question would be like not wearing anymore the shoes of regulators, but wearing the shoes of companies. Because when we speak about remedies, it's not only about remedies in courts, but contractual remedies is one of remedies that companies usually put in place to ensure that throughout the supply chain there is respect of human rights concerns. So I will leave it, and perhaps it started from Alison, moving the another way around, and Alison could give you her perspective from bottom up, up down, regulation and practices.
Thank you so much for the opportunity to answer this question. So I'm always obsessed with, okay, we have a regulation, how do we implement this regulation? It's very important for me. The part of this conference and the title of this conference, From Law to Practice, that was something I was very, very committed to. So for me, regulations are only as good as their implementation, and again, national contact points are in a unique position to help with the implementation of the SEALS DDD through sharing their experience, using their experience to help guide companies in the implementation of the new regulatory requirements. I think this legislative framework, it's not something I can talk very much about except for the implementation, but it's important that that companies use it as a guide, use it as principles. We heard earlier that it's not sufficiently detailed. Sometimes that's good. Sometimes that gives a little bit of room for adaptation to different kinds of companies, to different kind of contexts. Yes, for me, the key aspect will be the implementation. And we were discussing earlier also that some due diligence laws are already in place, and we're not absolutely convinced yet of their effectiveness, for example, in France, due to some bottlenecks that are going on with regard provision of remedy. The other question was bottom up. Yeah, I think we talked also in the preparation of this meeting about what constitutes an effect of meaningful remedy, and again in the follow-up of any kind of grievance that is being evaluated and concluded. There is a need to follow up not only from a distance, but also by talking to the victims and their representatives, and to understand whether they're actually satisfied with the result. Because again, we can tick some boxes in terms of kinds of remedies, but ultimately it really is up to the victims and the victims themselves, and if they can't speak for them, if they're unable because of capacity constraints, or to speak to their representatives.
Thank you. Regarding the first question, I think one of the positive outcome that I see in this directive is the standardization for all the companies that will play the same level. At the same time, the access to justice and the implementation that you were talking, and Karin also talked, it will be in 27 states with different interpretations and kind of implementation. That will be, I think, a pitfall, because, for instance, how we will enforce these challenges when, for instance, a business cross borders. I think it will be kind of tough to do that. For another aspect, I think it will cost for several companies, especially the ones that are not so prepared, is the cost of implementation of the measures that this CSDDD oblige. And regarding the second question, besides some mechanisms that I already told here today, I think companies can do a lot. Can do supply chain audit, can create some committees of supply chain audit. For instance, in SOMINCOR we have it. Can create, for instance, whistleblower programs, despite the fact that some companies are already obliged by law. For instance, SOMINCOR again as a whistleblower channel since ever. And I think these kind of mechanisms and tools will help facing the problem of the human rights violations. Thank you.
Yeah, just to add a little bit, I mean, I'll talk from the bottom up, and for me, the bottom up is from the communities and from the rights holders. I'll start with, I think that's just because of the work that I've done so far, I think, to bring that, make sure that voice is heard. But we've also done some interesting engagement with regulators on different pieces of legislation related to due diligence in the Netherlands. So there's some interesting things to be said, I think, about what the regulator would like to see from this law, what would make it easier for the regulator to do their work. But I think just from the rights holder perspective, and sort of, you know, from the communities and the workers in the global South that I work with a lot, I think, again, an important piece of this legislation is that power imbalance, and making sure that the legislation empowers communities and also empowers the regulator in that sense to really be able to enforce the law. Rebalancing some of the power asymmetries that exist when it comes to information, when it comes to resources, as Karin mentioned earlier, I think are really important. And one big pitfall, I think, that we've a couple of people have mentioned a little bit today, but I think we should all really be focused on, is this idea of risk shifting. And I know we talked about it a little bit in one of the panels earlier, and I see this as a big danger for the legislation, where if big, powerful companies, basically, in the global north are allowed to shift the legal and financial risks of compliance with the law to their suppliers in developing countries, that is going to be a huge, huge problem for obviously the suppliers themselves, but also the workers there. And another element of that too is shifting the risk to auditing and certification companies. And we know that there are several very serious proposals that are being discussed at a high level in Brussels about allowing sort of safe harbor clauses in the legislation, where if a company just gets a certain certification or does a certain audit, then the liability is taken away from the company. And that would be a huge, huge problem. The core of due diligence is that those types of mechanisms can be a piece of them. They can provide a source of information, but it's a huge pitfall if they become sort of a get-out-of-jail-free card, basically, that's just going to allow powerful companies to shift the risk away from themselves and onto another party. And then just from the again, from the regulator point of view, I think this idea of contribution and having the legislative framework and the clarity on the duty of due diligence with regard to which types of companies have contributed to a particular impact or a particular risk is really important. And I mentioned earlier the example of the financial sector. Financial sector companies and investors and banks, they have a role, and they supply the funding for business activities, but they are often seen in the regulatory regime, in the responsibility accountability regime, they're sort of shielded in a way because they're too far away, they're too distant. So it's really important that the regulators be able to include financial institutions in the scope of their regulatory activities, and recognize the contribution that they can play in, they can make to harms and also to remedy, as the case of the ANZ sugar case in Cambodia identifies. And then, as finally, the role of purchasing practices is also something that we talked a little bit earlier about too, in that big multinational buyers, retail brands, who employ certain purchasing practices that puts a lot of pressure on their suppliers, on the factories in the global south. They're demanding low cost. They're demanding quick turnarounds. You know, the whole fast fashion industry basically that demands that workers or that factories supply on short notice. These type of practices are not just, it's not just an innocent trading practice. It's actually contributing to the harm that's happening there. So the regulators need to be able to have this element, this understanding of contribution, and that needs to come from the law. The legislators need to give regulators this framework, which is embodied in the OECD guidelines and the UNGPs, if they are going to be able to effectively engage the wide range of companies that are involved in certain abuses.
Thanks. Thanks a lot. I think it was a fantastic panel. And by speaking, I would say from my own experience, thinking about remedies and the cases that has bringing us as a NOVA School of Law, it's a NOVA Green Lab, we have to think perhaps as a contribution, it's a type of the remedy sometimes changes according to the damage that is needed. If you were speaking about compensations, usually as a market instruments would have like AIDS associations, funds that finance this process of access to justice. When you were speaking about rights of communities that would have rights for injunction, but not necessarily damage, here you don't have economic instruments and forces to help them. Thank you so much. I would of course, Karin, we would have like questions from more ambassador students, but of course, of course.
Because I think there are, picking up on previous points, there are a couple of points that we haven't addressed here that are also important. One of them is the CSDD's setup of administrative agencies that will also be involved in with tasks related to remedy. Here too, there are potential overlaps with the secretariats of NCPs that already exist. There can also be an inherent competition within EU member states, which is not going to be very good, I think, for the delivery of a remedy for those who need it. There is also, if we look at the fact that civil servants usually do jobs for a relatively limited time, and then they might move on to another job in the same, say, government agency, another one, there's a big risk of institutional memory. And I want to say that, based on my experience with the Danish NCP, institutional memory is just so important, because NCPs don't have the same sort of systems for keeping track of previous cases or debates or decisions that courts have. So that's one thing. The other thing is the risk of turning all of this into a number game. Because what we see also with the EU, we see this push for sustainability regulation, which is really important, really needed. But we all see also a way in which issues that are easily quantifiable, like climate change issues and some environmental issues, are subject to increasing requirements on, well, reporting and quantification, also with the aim of preventing harm, but with an underexplored, I think, recognition of the fact that for human rights issues which are inherently qualitative, you cannot just expect that the same things will work, right? You can count how many fingers people lose in an occupational health and safety incident, but you cannot count the inherent or calculate the inherent organizational issues that lead to that problem to arise, right? So just two things that I think are related to remedy.
Wonderful. Thank you so much. I would like, we have like not much time. You have 5 minutes, but I would like to give it the floor for the students ambassador. So let's do like the following. You raise the 2 questions. Each one raise 1 question. Introduce yourself, give your name, make one question, and you have like a quick round in 5 minutes. This challenge, okay?
Okay, hi, I'm Olivia. Thank you so much for all of your input. It's really insightful, and I really value it a lot. My question is about the burden of proof, and I know that it can be challenging, especially for marginalized populations. And specifically, what I was looking at is in the context of gender and women in terms of sexual harassment, but just in general as well. How can the burden of proof be adjusted, and maybe provide some practical approaches as well to account for these challenges that individuals will face when they seek remedy? And we've talked a lot about power imbalances. So I think this really comes into play to ensure that individuals aren't discouraged from even seeking remedy in the first place or reporting the violations to these NCPs. Thank you.
Yes, hi, thank you very much. I'm Odile. It was very difficult to choose one question to ask, but I made my choice. And I'm going to ask your views on the SLAP procedures as an obstacle to access to remedy, and how to address that obstacle, including the potential of another EU proposal, the directive on SLAP procedures, and what this potential is. Thank you very much.
Okay, thank you so much. Who wants to start it? Okay. No.
Okay. Thanks. 2 excellent questions that we indeed communities face all the time, as you can imagine. On burden of proof, I mean, it's something that needs to be dealt with in the legislation. There is, coming from the voluntary standards of the OECD guidelines and the UNGPs, and often in NCP cases, there is a lower burden of proof. So if we're just talking about some of the differences between like a legal case and NCP cases, there is a lower burden of proof in NCP cases. And the whole, basically the name of the game in due diligence is knowing and showing, right? So the burden is on companies to show that they are doing the right thing. And in fact, in the OECD due diligence guidance for responsible business conduct, some of which has gotten now into the new OECD guidelines, and some of which we hope will get into the European legislation, is about disclosure and provision of information. And the burden is put on the company to provide the level of detail needed to convince a stakeholder, to convince a legislator, to convince a policymaker, to convince a court that they have done sufficient due diligence. So if an allegation comes up in a sexual harassment or any other sort of human rights situation, the burden in these cases is put on the company to prove basically that they have acted correctly. And so in that sense, that reversal of the burden of proof is really empowering for communities. We know, I mean, we can see in some of the European discussions now that that's a tough battle to fight. And I know in the French law, Canel and others can speak about that. That's been a huge limitation so far, and a barrier and an obstacle to remedy. So that's something that will definitely need to be addressed. But the principle, I think, coming from the voluntary standards is there, and if we could make sure that legislators build on that and build that into the legislation, then I think that could be enormously powerful. And on SLAP suits, it's something we face all the time, and it is hugely restricting, and because even if you are eventually able to win a particular suit, just the threat of it can be such a resource drain on communities and on NGOs that it is very difficult to get around. So there are support networks for civil society, anti-SLAP networks and anti-SLAP groups, And there is indeed the legislation that you mentioned, the potential upcoming legislation. But that's something that, again, we have to, the new version of the OECD guidelines basically explicitly asks companies not to do that kind of thing, not to engage in legal or physical threats of reprisals. So that's if we could get a piece of that out of the voluntary standards into the legislation, that would also then go a long way to remedying that. Did anyone else want to?
Just to add to this, in terms of the burden of proof, so due diligence requirements aim for companies to identify risks and to mitigate them. And I think one very, very powerful tool to do that is through engagement with the different stakeholders and just to get information about issues before they become really severe. In the due diligence processes, and this is also hard to teach to students, you're supposed to identify the risks, and then you're supposed to classify these risks. Now, knowing that an issue is salient is not so easy, and there are many different methodologies out there to help identify salient issues, but companies need to pay attention also to other kinds of issues, just in case they may also be undercover salient or may become future issues. And I think this sort of more preventive approach, in a way, also mechanically alleviates a little bit of this burden of proof, because then you wouldn't have to provide so much information about what's going wrong, because the company would already know it through operational grievance mechanisms or other.
Does everyone know what SLAP suits are? It just occurred to me that maybe not everybody knows. SLAP stands for Strategic Litigation Against Public Participation. So it's a legal tactic or strategy that companies sometimes use to file defamation cases, for example, libel cases against NGOs or communities that are raising their voices, so human rights defenders, and they charge these human rights defenders then with defamation or libel, and are able to shut them up, basically to stop their participation in the public debate, and it's something that's increasingly happening.
Okay. I think let's see. Could I? Okay. The boss said yes.
Yeah, thank you. The SLAP is Procédure Bayon on the French system. Concerning the burden of proof on the French law, the vigilance law, because you refer to it, which is indeed difficulty, you said it very well. In fact, what we may think is that under French law, you have three obligations: to have a plan, to implement it effectively, and to communicate. To which extent the obligation to communicate by companies make it that the judge has access, like NGOs and others, have access to all the information that the company ought to publish and to communicate, except when it is what we call the secret d'affaires, but that's something different. So to which extent, and I wrote an article on that, there is no system of what I would call a distribution of proof, not the burden of proof on one or the other, but distribution of proof, which does exist in discrimination between men and women in the law, by the way. And so we may wonder to which extent, because there's a sovereign power of the judge, if the judge under French law may decide that in fact he has access to all that information, that therefore he has the right to put questions to the company, further questions to be clarified what they communicated, and then there would be some remaining stuff for the victims. But this is it is a very prospective idea. Many lawyers in France, they challenge my position. They say it's going to be broken by the Cour de Cassation. I'm not sure.
I think with this, we had a wonderful closure of the panel. Thanks so much for the speakers, for the keynote, and applaud. I would like to close with